mentions.
Item 801.
Please, Lordship.
10 September.
Yes.
Item 802.
Madam.
802, we'll take it up tomorrow, but in this letter, you have said that you brought out a notice on which day? 22/8/25, one day after our order.
Yes, yes.
That's a public notice, is it?
Yes, yes.
Published in the newspapers,
Given.
and 2,000 people have not come forward.
Your Lordship.
No, only 13 people. 13 people have come.
No, you said total number, you gave the total number here, 13,800 candidates out of approximately 15,800 candidates
Yep.
have submitted their application.
Yeah, they have
forms. That means 2,000 have not submitted.
Your Lordship.
Nearly.
Nearly 2,000 have not come forward.
Nearly come forward.
Your
But
Lordship.
after that, my lord, 13 applications have come.
13 more have come.
13 more. And
There's one writ petition today.
one
Sorry,
petition
one SLP today.
my lord, only our concern is that up to third, anybody can make the application. We don't have the difficulties.
Up to third, is it?
Third.
Second.
Sorry.
Second.
Up to
Up to
second.
second.
Up to second.
Second.
And then the 7th September, my lord, we want to proceed with the selection
Sorry,
process as per.
Sir, we only said accordingly. Well, you want that clarified, we'll take up the application tomorrow.
And yes, and another thing, my lord, kindly just excuse me, that the last line.
Accordingly, that is what we said, it'll.
Yeah, accordingly.
Accordingly.
If it is necessary, my lord.
That will clarify.
Well,
It shall be postponed accordingly, we said. You are appearing for
Your
whom?
Lordship, I'm appearing for the untainted
Those who
candidates
were
here.
selected and appointed only
Yes, Your Lordship.
will be
So
covered.
I'm appearing for that category only. Unfortunately,
Then if you are selected and appointed, they are bound to allow you to participate.
there are.
You can't ask for
In which
postponement
I'm
of the
just asking for my application and SLP also to be listed together because there's much which I have to show to
You
your
have
Lordship.
perhaps one SLP today or.
My lord, one SL is today.
One.
Lordship,
That's
the
my essence.
Yes.
problem is that the tainted students are also being given admission.
No.
I haven't got them.
We've already noted one
I have
order
got-
passed by the High Court
No,
in
no.
that Vivek Parya, that order had.
MA and an SLP, your Lordships may list
No.
it together.
We are going to keep these matters pending, though they wanted Vivek Parya also to be disposed of,
Yes, your Lordship.
because we really suspect your bona fides. You're
Yes,
not being
your Lordship.
straightforward at all. Despite
Because
going through this entire process, you still want to favor your blue-eyed persons.
After the division by.
Why would you go before the High Court and ask for permission to allow the tainted candidates to appear?
That is the point.
Unless you have a vested interest
I
there.
will-
Lordships proposal
No,
that they
nothing, my
dispose.
You went before the High Court,
But-
Ms. Dwivedi was there.
Yes, but-
Perhaps you were not there on that day.
Lord,
The learned senior counsel who appeared in that matter showed us that order,
yes, is right.
and that does not reflect well upon you at all.
But kindly excuse me, brother. When the parent matter came, that
Vivek Parya.
Orunima.
Arunima Paul was
You
different.
dismiss that. But in that matter itself, our arguments have been recorded. Also for
Arunima Paul was not a candidate who had been selected and appointed. Therefore, you can't equate these people with Arunima
No, I
Paul.
am not equating. I am not equating. But there they one judgment, Vivek Parya's judgment, in the case.
That's only an interim order, it's still pending.
Yes, your
No,
Lordship.
here, the main matter,
Or in the-
4550, that has been, why 45?
We have only said that you will not apply that enhanced eligibility criteria.
No, we don't have.
Those who were selected and appointed who are to be permitted as per the concluding paragraphs in our judgment.
Not everyone has applied.
You said 2,000 candidates have not.
No,
come.
no. Those who are
Lists
coming
are
to your
ready
lordship,
and our SLP.
The-
Those who
Those
was all
who
the.
choose not to come forward,
Yes,
very
Your
well.
Lordship,
So
there
let
was-
that.
well, those,
Record will show
may I,
If
may
you have published the notice in newspaper,
I,
and in spite of that, they don't want to come in for the
Well,
selection,
may I-
perhaps those are
we have-
people who
we
have
have-
gone back
we
to
have
their
given,
old jobs.
we have given, if your lordship kindly just permit me to, just a little suggestion.
We'll hear you
No,
tomorrow.
one little
This
suggestion.
application will take it up tomorrow.
Yes.
And your Lordships, I'm
But another matter is,
my MA number.
It to be listed
My lord.
tomorrow.
Well, your Lordships, I'm giving my.
but another matter is there.
Filed a fresh SLP.
Yes, your Lordships against their orders only. And
The same
Yes,
judgment.
Your Lordship, same group.
And you are also selected and appointed candidate.
Yes, your Lordships.
Very good.
And there is
Relative.
26 where untainted, selected, appointed.
You will be
teaching.
permitted to
Yes.
write the exam.
Yes.
So
Well,
But you can't ask for postponement of the exam. You can't ask for
no,
postponement
we are
of the
not asking.
exam.
We're
We are
exactly.
keeping the matter pending.
We're exactly.
Tainted
what the Lord-
candidates.
No sifting mechanism to weed out the tainted. The state has not arrived. We're only on that, my lords.
Very well. That we
We're
will
working on
keep a
that.
check on, let the
Yes.
selection go through.
Yes.
If you're able to
Yes,
show
my
that any tainted candidate has been selected again, you will
My-
face the music.
My lord, I can.
If you allow, you have the list of tainted candidates
Yes,
we have-
by the
we do.
CBI.
We are not.
If you are allowing any of those candidates to
But
appear
this-
again,
but this
take
act-
it from us. We will
But-
come down on you like a ton
My
of
lord,
bricks.
Yes, my lord, kindly allow me. If this is the allegations are made,
This allegation
let them
is
show-
already borne out by your
let-
application
let
before the
them,
High
let
Court.
them show now.
Allow the tainted candidates to appear again.
Have not-
Why would you go before the High Court and even make such a prayer? Why would you do that? Once they have already been identified
Your point was.
as tainted candidates,
Your point.
you go before the High Court, file an application and ask for permission to allow them to write that.
Miller, the point was there. Just, I will make my summation.
There is
I am
no
not
no
supporting.
justification for that
Miller,
at all. Unless some minister wants some candidate.
No,
to
no, no,
appear.
I'm not supporting anything.
That is
Miller,
exactly what you're
ministers are
doing.
cordialation, those who are handling the. matter.
Anyhow, as we said, we are keeping a close watch on what you're
Yes,
doing.
yes.
Please be mindful
Please.
that we will
My lord, my lord.
definitely interfere
My
if you do this kind of
My lord.
tinkering again. You've already ruined the lives of these people. People are out on the roads. We are being blamed for your mess. Is that fair? The government, you're supposed to be a model citizen and this is what you do? A selection process tainted because some minister wants his candidates to be there. Your God knows what else went on. But you are responsible for this entire selection going awry. No other.
Miller, we
Word for
are
it.
neither the state that.
All the authorities concerned, the board, the service commission and the state government. All three are.
We are accepting that. Whatever.
Nothing more to be said.
Miller, we will also keep. Miller,
Very
one.
well, we'll take it up.
Miller, another one matter that which was hard on Monday.
IA and the.
Miller,
Yes, sir.
Miller,
Yes,
one, Miller, kindly just one the Monday the matter which was hard by your lordships and notice a similar order. Kindly let this come also tomorrow. Miller, although I have not filed
Why
any
should it come tomorrow?
along with
We've
this
already given the same interim order in that.
same interim order, but that is the clarification which is.
Again, in that also you
That-
filed an IA.
No, I have not filed I.
Then why should you?
Well, because
You took the trouble to file an IA in this. Why didn't you file it in that?
process of filing the IA because this has just come on Monday, but it repeats the same order as Vivek.
Very well. Give that number also.
Well, I am trying to file by itself to the IA, but if this number is we are giving, if it is there,
This last line doesn't really hold you to a mandate,
no.
which is how you're understanding it.
Yes, but for the all.
If you are able to entertain all the applications within time, and there is nobody who will come forward and say that I'm sorry, I ought to have been entertained, I have not been entertained, then of course it's a different matter. But if you've given time till 2nd September and you publish.
I will take all
notice in the
applications.
newspapers,
Unfortunately,
There are
what's
only
happening
one-
is that our school exams, term exams are in September. So all of us who have to take the exam, your lordships, this is the reason why they are putting a particular date so that we can appear and we don't have time to appear.
No.
So I'll show all this,
Teachers, you're
Yes.
already there.
all this to your lordships.
We are not going to put off the exam.
No,
Be certain about that.
asking for that.
We've
but-
already said that this process has to be completed by
Absolutely,
31st
your
December.
lordships, every direction your lordships have.
We are
given,
not
they
going to
violated.
postpone the exam.
I'm not on that, your
You
lordships.
need to burn the midnight oil to prepare, so do it.
All that I'm saying, your lordships, is every direction that your lordships have given has been violated by them, which I will show tomorrow
look
to your
it up.
lordships. Yes, great.
Filed the IA for this.
The legal-
The other one.
They have not.
IND.
It's a 15 minutes.
Very grateful, your lordships.
It's
80.
Please, my lords.
803 18th November. We can't give you a date.
My lords, I am only, my lords, the only difficulty.
An earlier date than 18th November because there's no point in just flooding the list. when we are not in a position to take up all those matters. You'll just be satisfied with being at the end of a 90-item list then?
My lords, I understand what is falling
We'll
from
only
my
be wasting
lords.
paper, nothing will come out of it. So you'll have to take the dates that we give. So
My lords, I
18
completely
November.
understand, but just one small submission which I want to make, my lords, in this is
We've
that,
already read what you've said in your letter.
my lords,
If the successful auction bidder backs out, that's his lookout. That'll be your misfortune. We can't do anything more than
Uh,
1811.
Please, Your Lordship. Your Lordship. Your Lordship, it's a criminal matter where
November.
55 days undergone and he has been enlarged on bail in a 302 matter, who was absconding for cancellation of bail, Your Lordship. I'm an injured victim.
Cancellation of bail will come on Wednesday or Thursday also.
Yes, sir.
So these days, everything is coming on Wednesday.
Right.
Item 1.
Please, my lords.
So counter affidavit.
My lords.
While in this case, I'm appearing for the respondent. The counter affidavit has gone for signature, but it has not returned after signature, my lord.
You send this counter for signatures.
My lord, that's true, my lord.
My lords, this will have.
This cause of action doesn't arise at all in the context
Please,
of 138 NI case.
That's true, my lord.
All you have to tell us is whether the respondent has a bank account in Solan.
Yes,
If he has a bank account,
Yes.
so it demonstrates
Yes,
that. then.
he has it. My lords, can I just point out one thing, my lords? Please have the office report dated 4th of February 2025, my lords.
4th of February,
2025.
are you going back? You have plenty of.
There are 3 connected matters, my lord, and the same petitioner has filed a matter which has been connected to those matters, my lord.
Taking up this matter, the other matters, we don't know where they are.
My lords, this is connected, my
Then
lord. Same
counsel for-
petitioner has filed.
Same petitioner against the same
Same-
respondent.
No, my lords, not the same
Then
respondent.
they're
My
not.
lord, the same question, my lords. This has been tagged with these matters, my lord.
I had said, in
Unless
fact,
there is already a tagging order.
My lord, yes, my lord, please see this, my lord. My lord, same petitioner, same question involved, my lord,
Further proceed.
tagged with the same matters which are here, my lord, which have been pointed out in the office report.
Will you address a letter to the registrar?
my lord,
Counsel
I
for
had ticket number 608 of 2024, my lord. It has been held that in 138 matter, this jurisdiction transfer.
Cause of action will not. Are you in a position to demonstrate that he maintains a bank account at Solan?
Yes, my lords.
Where is that? Have you
My
filed it?
lords, right now I'm not filed, I'll file it, my lords.
This issue of all disputes, jurisdiction at Badi, all this will not
Lord,
arise.
My lords, in fact,
This is
this,
not a dispute. This is an offence under 138.
no, my lord, this is also being.
And counsel for the respondent seeks some time by the counter affidavit. Needful should be done within 2 weeks, 3 weeks. Joined thereto, if any, may be filed within 1 week thereafter. List along with TP criminal number 121 of 2025 and TP criminal number 334 of 2024, which have already been directed to each club with this matter.
Grateful.
My lord, might be directed to produce the bank account details that they are saying that it is in
That,
Solar.
that will have to be shown. Otherwise, this case will have to go on that sole ground.
I love that, my lord.
Item 2.
Sir,
May I please,
Lordship?
Lordship? I am for the petitioner. May I please, Lordship?
when was the respondent served? 19th May.
Yes, Lord.
Expired. Expired.
Deeply obliged.
Now, date for appearance will be 17th September. Date for appearance before the transferee court.
Deeply obliged, Lordship.
I am permitted to serve through email, madam.
Service is incomplete.
Through email, I want to do.
When it comes, not through email, please. We don't know whether that is the
Physically, how
address
can
of
I
that
go to
person.
Mumbai? My lord, it's not possible for me to
You
go
can't do
physically.
it through email.
What lot of fresh notice may be issued, my lord?
Fresh, then counsel for the petitioner shall effect service of notice afresh upon the unserved respondent. Service shall be effected by all modes, including this.
Obliged.
List of the service of notice. Item 4, service is complete. You want to query?
Yes, my lord. Sit.
Lords, I appear for a petitioner wife. The service of the respondent is complete. However, none appear on his behalf.
Very good. Hello. Appearance on 25th. Appearance before the transfer court, 25th September.
Please, Lords, in item 5.
Why there's a letter?
For rejoinder.
I appear for the respondent that I think this is a matter which could be referred to the mediation center. For this
Appear before mediation center.
Lords,
Mediator on 25th September.
Kindly make it virtual because both the parties, he is HIV positive and he's not in a position to travel. And he has a 75-year-old mother, whereas she is in Ujjain. So we could.
Mediation proceedings, command to the extent possible, may be conducted online. To the extent possible.
Yes.
In the event the
Yes, of
mediator
course.
requires
Yes,
you
of
to
course.
be present.
Because then one
Please
more
be
submission,
present.
because if it could be sent to a senior mediator, because it's, there has been some issues.
Lords, I am agreeable to the suggestion because my client really want to settle this issue.
Also request that a senior mediator may be appointed to undertake the process. The learning coordinator of the Supreme Court Mediation Center may therefore consider this request also.
Deeply
Grateful.
There are two.
One is a divorce.
Respondent seems to have appeared before the registrar and
Yes, Your
said that he had no objection.
Yes, Your Lord.
Is he appearing today? Anyone? Is there? No? Once he said, so for the registrar anyone. He's there, but he's not.
It's connected, but there is some problem.
No, the problem is
already made a statement.
in the light of the registrar's order, the court of, in the light of the order dated 11/8/2025 passed by the registrar's court, recording that the respondent appeared as a party in person and stated that he had no objection to the transfer of the case as sought by the petitioner. We allow this transfer petition.
There are two matters. One is a.
One is the suit.
Yes, Your Lord.
One is from the. Two separate. This you can put in.
My lord.
For the transfer report on 25th September. Is he appearing?
My lord, I am respondent number 6, sir.
Six.
Item number 6. Yeah. My lord, I want to make one submission.
Yes.
It is second marriage for both of us, and I want to settle it peacefully. I would be grateful if you refer it to mediation cell.
You want to go before the mediation?
Your Lordship will appear before the trial court mediation center because
Yeah.
if that serves the purpose.
We'll go before the trial court's mediation center.
Yeah, we went there, but it was not settled there.
So it is better you want to go before the Supreme Court mediation center.
Yeah, right, sir.
I have no objection.
Then mediation.
Thank you so much.
Appear before the Supreme Court's mediator on 24th September.
Ji. Thank you, sir. Thank you, my lord.
For the petitioner,
Yes.
the service is complete in this matter.
No one is appearing.
Is appearing. We have apprised the respondent counsel.
this is
trial court also.
No, divorce case. Very good. Ex parte order. Appear before the transferee court on 23rd September.
Grateful. Much obliged.
Made.
Let's this
No
the
counter.
parties wish to set. My lords, the matter may be referred to
Mediation.
Please, my lords.
Very good.
My lords,
Mediator.
virtually if the parties will be permitted to appear because I have a minor daughter, my lords. Okay.
23rd September.
So, I'm open.
May I please, my lords.
We should notice on your IA, who's appearing.
Yes.
The instructions with regard to this surgery.
Lordship, the reports are legit, so we will be present.
You have. IA number 1414978. In the copy of the IA. Take it. Take it. 1. 6. Interim pay on the ground that he has to further. Second, this is the second
surgery. Followed.
second surgery. In terms of the medical certificate. Where is that?
Annexure P6,
C6.
page 17.
In terms of the certificate dated D11/2023 issued by the PWM Orthopedic Hospital and Kanyakumari. It's in at Nagarkoi, Kanyakumari district. That comes with the state. I can verify. The documents by states that she has no objection for a limited period on this. The applicant be released on interim bail on terms and conditions to be fixed time for a period of
6 months, 15 days, my lord.
6 months. Why 15 days extra?
My lords, because recovery period is 6 months, my lords. So for surgery and release.
15 days to relax.
For release and general commutation.
We'll make it 7 months. For a period of 7 months. The applicant shall surrender after the expiry of the said period without pay.
Deeply obliged.
So item 10, the office report.
Transport record here.
Sir, one of the petitioners
is directed to follow on and put your transport records. List the specially petition for. This is a 2021. We grant leave then.
No, my lords, may consider.
Otherwise,
no,
it will only be on a Tuesday.
No,
Appeal of the
no,
appeal of the
my
court is already dismissed.
Oh, it's already dismissed.
no, my lords, I have instructed.
Then we'll just give you a date.
Yes.
Can
Can it be on 18th? 18th? Or in the meanwhile, may I pray for bail because one of the applicants.
Lord, in view of the ongoing festival in Maharashtra, I'm not opposing vehemently, but I will have bail after this. 3 bail have been dismissed.
This from 16th September.
Obliged.
Wait, please. And what is this?
This also you have to. The earlier order granting bail.
Yes, Lord.
Did not extend that relief to you for some reason.
No, Lord, on that day,
The rule attributed to them has been different, which.
the lordship question is different to me, it's a
And you only less than 8 years.
No.
Directed that the matters be.
Listed for hearing.
That was the Lord A or something. Lord,
28/7, your lordship.
Lord,
We commencing 28/7, it was.
my friend will laugh at me, Lord, I am the petition applicant here. Lord, when your lordship passed the order of Mirajul, on that date, Lord, on that date, only the application of Mirajul that had been filed was listed, Lord. My application was not listed that day. Lord, second thing, Lord, if your lordship just has my custody, I have been inside for 11.5 years, Lord, with
Not
remission.
correct. With remission, it doesn't count.
Without remission, over 8.5 years.
Less than 8 years. Both of
Lord, please have the, Lord, I filed this custody certificate, the latest certificate. Lord, it's in IA 205370. I've got extra copies, Lord, for convenience. 205370. Lord, in that the custody certificate, Lord,
yes,
is.
Please count the number of days that you were out.
Yes, no, my Lord. But the
Custody after conviction, 8 years, 1 month, 20. This is for Syed Ali.
Yes, my Lord.
8 years, 1 month, 23 days. Custody as under trial, 2 months, 15 days. That makes it 8 months. 8 years, 3 months.
Yes, my Lord.
Or 8 years, 4 months.
Yes.
And the period that you were out.
Lord, that
is
already
27, 47, 77, 107, 127, 157, 177 days.
That
Which makes it 6 months.
Lord, if your lordship sees
This is as on 10th August.
if your lordship sees entry number 6, it says actual undergone period. Lord, in this calculating this actual undergone
period is not extracted. The parole home leave availed has not been extracted from this period.
Lord,
So
there is
the
nothing-
period that you were actually out on parole or home leave, whatever they call it, that is not going to be treated as incarceration.
No, I understand that, Lord, but that the calculation does not show that it's not been.
I'm doing the calculation. The details are given of the period that you were out.
Says the word actual, Lord, my submission.
You're not going to ask that. You can look at what has been stated there.
Lord, 8 years, 2 months.
8 years, 1 month, 23 days is
After
what is
conviction.
mentioned
After conviction.
in item 2 as well as item 6.
Item 6.
And this period under item 3 has not been deducted.
Lord, there is nothing.
Council, at least apply your mind.
Lord,
it is clear that this period has to be exacted. It has to be excluded.
But this has not been, Lord.
They're giving you a date, you will have to wait.
Lord,
We are not inclined to entertain.
Your Lordship will keep it pending. Your Lordship will keep the application pending. Your Lordship will not send in the bail application. Your Lordship will consider it on the date.
We are not entertaining it. 1777807 of 2025 is accordingly dismissed as the matter is live for hearing. The registry is directed to list the appeal for hearing on 8th October.
Your Lordship will kindly, I will not dismiss at this stage, will not, so that doesn't.
8th October, we are hearing the appeal. Be ready.
Lord, on 28th April also, Your Lordship had said so, Lord.
I've given you a specific date. Earlier, week commencing meant it would come perhaps during the week or may not. Now you will join the queue, so be ready when the matter reaches.
I'm grateful. May I please, today he is in prison for 12.5 years. 12.5 years. 11 years. 12.5 years.
Nobody wants to exaggerate the period of incarceration. Earlier council, now you're also doing it. How long was he actually inside? The precise figure will give us, not embroidered figures.
Lakshma, can you calculate 74 months? 11 years, 3 months and 11 days.
In your eye?
15,424. 74, page 74.
74 of the SLP.
Yeah.
Yes.
Custody certificate. Lakshma, can you total period 11 years? 3 months and 11 days. As on 15,424. No bloods only have gone after that. Therefore, I submitted it is more than 20 years.
You've not been granted parole at all?
No, no problem.
At all?
Yes.
Is that possible?
But the problem is this.
No, most of these custody certificates, they don't seem to disclose the correct details in terms of the period that you were allowed to go home. At least in that earlier one, the details were furnished, though the deduction was not made.
We go by this only. One more problem in this matter is, kindly see, so far as the other accused co-accused
Who's appearing against you, notice was issued on your application also.
Notice served,
Notice
served on them. Opposite put
29,720. Not sir. Service not complete is what?
Say, but you read, sir, you please read the note. He was in jail in some other case. Please read it.
Well, that case on 25/10/2020.
Will have to be deducted too.
Concurrent.
This was a separate offense altogether.
Yes. But you have to verify.
This is not a concurrent sentence.
No, you have to verify.
You were already in jail in relation to some other offense. So this sentence will commence after you complete that.
And in this case, he is in jail.
The court will give concurrent finding, concurrent sentence. That is to verify.
Anyhow, there's no notification for the state. Without the state appearing, we are not going to entertain you.
One more thing, Lord Smakali, consider it.
Anyone for the state of Jharkhand? Service is complete as per the office report. Nobody is engaged to appear.
I am not engaged in this matter.
But the state needs to be a
I can seek instance. Please.
May I submit one.
There is no representative
Only
of the
one
state of Jharkhand. Strike service of notice, Mr.
Dr. Sudhir Bisla.
Dr. So-and-so, who is present in court, states that he You're a standing counsel?
Yes, sir.
He is a standing counsel for the state of Jharkhand, but he has not been engaged to appear in this matter. He, however, offers to obtain instructions and appear in the matter if instructed to do so. We accordingly adjourn the matter to enable the state of Jharkhand to respond to the plea of the petitioner for grant of bail pending the special petition.
2 weeks, sir.
How much time would you require?
2 weeks is sufficient.
This on 10th September.
One small submission that I will make, you have to kindly get me for this. There is difficulty.
No point in
I'm not
you're saying
saying
anything. We will not be able to remember till 10th September. So why are you wasting your
There
time?
is another accused, but his appeal is pending in the High Court. Therefore, this cannot be disposed of. It's a problem.
His appeal is still pending.
Yes.
And, we are not disposing it off. You only said you're a build up.
Please.
Whatever you need to say, say it.
Please. Let me get an instruction on that also. That's why it is. Great, sir. Please. Your service is complete in this matter, my lord.
But this also there's some confusion.
Yeah.
He is still in jail, is it?
Still in jail, my lord. But the stay has also been served to his wife also, as well as in the jail, my lord. There are 27 matters pending in this matter.
But service is complete by way of dusty service.
Yes.
Dusty service inside the prison.
Inside the prison as well as his wife also, my lord.
And no one is appearing.
So no one is appearing. Kindly, I have page number E, my lord. There is 27 cases.
27 cases. From the court. Service of notice, the respondent has not chosen to enter appearance. The Supreme Court Legal Services Committee is requested to engage a learned counsel to appear on behalf of the respondent as the matter pertains to cancellation of receiving based on 17th September. 17th.
Please. But this matter comes up.
So district judge
has been appointed.
District judge has been appointed.
3rd September is when it is for framing consideration of that.
Then we'll adjourn the matter.
Well,
your discharge application is pending. If we say anything against you, it may weigh against you there also.
But
So
today,
in your own interest, I think it's better that we adjourn the matter.
can I just make one request, Lord? The High Court has said everything that needs to be said. See the High Court order. Today, Lord, after this, what am I going to get? Let's just see the High Court order. And it's been not, it's a DA case where the amount is, it's a trap case. Where
Which
the
paragraph of the High Court order?
Now, Lord, just see this. Lord, if my Lord just gets the High Court order for a moment, please just come to para number, Lord, 14 onwards. Sorry, that's 14 is this one? I just came. Yes. 31, Lord, 31 will be at page number 7. 31 onwards. And
all general observations.
Lord, now come to 33. Applying the principles to the facts, this court is satisfied that element of demand has been established. Prima facie established.
Prima facie.
My Lord, but that's the test of charge. And not consider this. Admittedly, it's a loan amount as per the main witness, as per the main complainant. Please see, Lord, 31, 34.
We'll make it clear that the discharge application will be considered by the trial court.
My Lord, would your lordship
uninfluenced by the observations made by
can I just
in the improved order.
Lord, can I just request your lordship? But today, Lord, I'm only here for bail.
That is why we are saying, in
Your
case we hold against you, that will reflect definitely upon your discharge.
When would your
So
lordship?
in your own interest, it's better that we adjourn the matter.
I leave it to your lordship, Lord, I can't disagree with that.
We are informed that district judge has now been
Yes,
appointed.
special judges.
Special judges.
Special judge, no, it has to be special judges.
Has now been appointed, and the discharge application filed by the petitioner, which is directed to be listed in the month of September.
3rd September, Lord.
On 3rd September 2020.
Lord, may I just say,
is now capable of being taken up for hearing and disposal. We accordingly adjourn this matter, leaving it open to the trial court, and the special court to deal with the said application on its own merits and in accordance with law, uninfluenced by any of the observations made in the impugned order and the pendency of this special.
well, not just one request, Lord, I believe, not here, Lord, in the northern states, we don't move discharge, it's argued on charge. So my Lord may just say consideration of charge is restricted. It's listed for arguments in charge. Here we don't move discharge. Lord, it's arguments in charge.
On arguments.
Lord, one more thing I must point out, my learned friend can verify this. I have the order of the Honorable High Court directing him to be appointed as special judge subject to consent of the state government. We've not been able to locate the consent of the state government. My learned friend may just verify that, because that's the only catch.
Is he taking up matters or not?
But he's taking up matters, but till the empowerment happens, that may be an issue. That because we tried, we couldn't get the notice.
Let us see whether he says something.
Grateful, deeply.
So this complete.
This case, Lord, is
This is complete. No one is appearing for the state.
Lord, I have a clutch of papers, documents to show that I'm cooperating, Lords. So the other side is not yet, so we'll have an interim order.
Council has also gone.
So if 1 month, Lords, I'll file these documents, Lords.
There is no representation for the state of Jharkhand despite service of notice. This is the usual case so far as the state of Jharkhand is concerned. Notice may be sent by the registry to the Chief Secretary of the state of Jharkhand to take note of this careless lackadaisical attitude on the part of the state in entering the parents before the Supreme Court. Based on 7th October, earlier interim order shall continue.
And I'll be permitted to file
21/7/2025 shall continue to operate in the next state of Share.
Well, I'll file some documents, Lords, to show that I was cooperating, Lords. What should indicate that?
Then comes to the petitioner is at liberty to file additional documents, if any, by the next state of Share.
Steve?
Lordship pleased to issue notice on 21st July. They had filed a count that day.
Counter is fine.
Yes, sir. Yes, Your Lordship. It has not
When?
come on record. Yes, Your Lordship, 20 PM. It has not come on record yet.
You need to file a rejoinder, not this. Then comes for the state, states that state of Rajasthan states that a counter affidavit was filed on 26th July.
Yes, Your Lordship.
26th July. July?
No, yesterday.
August. However, we do not find the same in record. Then counsel for the petitioner states that he does not wish to try a rejoinder later. For the state to verify and put up the counter by the next date of hearing. This is also bail. So we'll take it up on 10th October. Sorry, 10th September, not October. 10th September. Bail matter.
I'm saying for Passover in this matter because when argument counsel is occupied before another bench.
You can argue. You can argue.
I can't.
You can't. Why not?
I'm not ready.
You're not
Ready.
ready. Are you not attached to his office? Are you not attached to the office of the AOR or the arguing counsel?
I'm attached, but I'm not ready. No.
Not ready in the sense you read the papers, but you are not ready enough to argue.
But I'm not also have the file.
You don't have the file.
Yes.
But you must at least carry the file. What do you have with you? You're carrying your iPad, isn't it?
Yes, yes. Sir.
Then on the iPad, the file must be there.
But just I got the brief from the senior counsel.
When? You didn't read it.
Yes.
But unless you read the briefs, how will you follow what is happening? You've not read this file at all.
Yes. Yes.
That is bad. When did you get it enrolled?
On 22.
22. 22. 3 years have passed then.
Yes. Yes.
And you're not reading the office briefs.
Yes, sir. Recently I joined this office.
You recently joined. But that doesn't mean that you don't read the office briefs. You must read the office briefs, isn't it? You never know when you will be called upon to argue. You must at least be prepared. 3 years down the lane, and you're still not picking up on that.
Just 1 year ago, I joined this profession.
You're only spending time here while preparing for the mains,
Yes, sir.
civil services.
Yes, sir.
But even for the civil services, you need to have more application of mind. Anyway, then comes for the petitioner 600 adjournment on the ground that the arguing counsel is held up in another court. List on 24th September.
Well, this is an anticipatory bail application in a case where I've been claimed for the abatement to suicide.
Dying declaration to the executive magistrate. You've not filed it.
We just point out.
Why have you not filed it? You've not filed a copy of the dying declaration.
Because we do not have the copy.
How can you not have a copy?
Because that's to the police, that's not in, this is my anticipatory bail.
At this place that dying declaration.
For the
complainant.
You are for the complaint.
Yes, ma'am.
State is not.
These are a KVA. My lord, this is a fresh.
I was hurt by the
It's a fresh
Honorable High Court.
You were hurt by the
Honorable High Court, my lord. I was hurt.
When you appear before the High Court, at least ask the High Court to implead you.
Yes, my lord. Lordship, sir.
That's not happening because the cause title doesn't reflect the name of the complainant. Complainant's counsel is sir.
Lordship, sir.
But he won't be made a party here because he's not there in the area.
Lordship, sir. I was hurt with that. And I filed written objections also which are not on record.
So, my lords.
You have a copy of that dying declaration?
That I also don't have, my lord, because the trial court, my lord, it's part of the trial court record.
Not even trial court, it's still the.
In the investigation.
It's part of the investigation, yeah.
The complainant who is on KUMARand is included form as respondent number to give the details.
Yes.
As he was heard by the High Court while passing the improved order. Issue notice to the state of Gujarat, returned on 17th September. This is an anticipatory bill. Normally we would grant protection. What do you have to say?
On 14th of August, my lord, an application was
That is what he has to say against you.
On 14th of August, an application was filed by the police officer before the learned trial court that, my lord, all the petitioners are absconding. A statement is made in the synopsis that, my lord, they are ready to cooperate, they will investigate and they will appear. But on 14th of August, an order is passed by the trial court that they are absconding, my lord, from the trial. Therefore, my lord, custodial interrogation is required.
Now we have only one brother before us.
My lord, there are two other SLPs also filed, which are
the wife and the other brother.
And the other brother, which are in defects, my lord. All of them will appear, my lord, perhaps someday. They are not cooperating, my lord, since April.
These are people who have been married for a very long time.
26 years.
Are 25 years old, 20 years old.
He was mentally, my lord, harassed, because of which, my lord, he committed suicide by endorsing fire.
FIRs by the wife against him.
My lord, those are 2022, my lord. I am instructed to say that there were many FIRs, my lord, between the parties, my lord. He doused by fire, my lord. He put kerosene on himself. The most difficult form of, my lord, suicide that can be committed was committed by him. He was harassed, my lord. That is the reason I am opposing.
It's 10 years.
10 years or 7 years.
10 years.
10 years.
10 years. cooperate with the investigation. At this stage, perhaps incarceration is not.
Your Lordships are dismissing
No, we are not dismissing, we are granting interim bail also.
Lordships will consider hearing me after notice on the date.
File your reply.
File your reply till then let it cooperate with the investigation.
They have not
be arrested.
since 9th of April until the direct. May I just take this? From 9th of April, my lord, when this act had occurred, they had once, my lord, come for the ceremony, my lord, which was funeral. After that, my lord, they have not appeared. This is the order by the trial.
You have the petitioner's complaint against the deceased on 9th September 22. Then Rita Ben's FIR, the wife's FIR is on 11/2/25. 9th April, he commits suicide.
All of those are 2022.
Really, because they filed criminal complaints against him. If he committed suicide, that is not perhaps a ground for a 306 conviction.
Sorry, my lord, the suicide had occurred in.
Now you have Justice Vishwanathan's judgment on 306. So unless you pass that standard, a 306 perhaps conviction would be very, very difficult. Abetment of suicide, you need to really put it beyond the pale of doubt that this person had no other option because of the action of the accused except to commit suicide.
The FIR will not
really saying that he was depressed and they did something so it added to his depression. Those are all subjective standards. You never know what will particular person be.
My mother and said that he was fed up
Where
with
are you
his life.
reading?
Lords, page 58, last two lines.
Last.
Lords, got that?
Yes.
About 15 days ago, my younger brother Prashant Bhai came to my home. He sat with me and my mother and said that he was fed up with his life. He stated that his wife.
You said that they did nothing about it, though they knew that he was feeling depressed.
15 days back, he comes and makes a statement. He is in a close proximity with the victim and he was not
60, my lord.
60.
Yes, my lord. My brother told me that for a long time, his brother-in-law Rajesh Bhai Thakkar and Bharat Bhai Thakkar, along with Bharat Bhai's son Jamin and his wife, had been pressurizing him to become a Ghar Jamai. He said that they had also forced him to transfer all his property and bank lockers to his wife's name. He also said that the house in Tirupati was also in the name of wife Rita. Furthermore, he stated from the partnership business, they were in partnership together. They owed him 73 lakhs while he owed them so and so. He stated that to avoid paying him this money, they were pressurizing him. They had also taken a loan of approximately 35 lakhs on his house in Tirupati and had taken his Activa scooter also. He said that for the last 2 to 3 days, these people had been repeatedly threatening to kill him if he did not vacate the house, which made him very frightened. So he had bought petrol from outside, doused himself, set himself on fire, and ended his life. I recorded a video of this conversation on my mobile phone, which I will present for the purpose of investigation. My brother had also previously sent me a 5-page letter on 22/1, in which he had mentioned the mental harassment he was enduring from his wife, Rita Ben, and his brother-in-law. I am submitting a copy of that. I have also learned that my brother Prashant Bhai had posted an audio message on his society's WhatsApp group before setting himself on fire on 9/4, stating that he was burning himself because of the harassment from his wife, Rita Ben, his brother-in-law so-and-so, and Bharat Bhai's son so-and-so. My brother Prashant Bhai, resident of so-and-so, so-and-so, due to the harassment from these people, doused himself with petrol, set himself on fire inside his house on the morning of so-and-so. Then your lordships may see, my lord, the trial court order where, my lord, they had applied for the bail. That, my lord, your lordships will get.
Page?
Yes, my lord, I'm sorry. The analysis is at, my lord, page 159, but the order is, my lord, at 144, my lord.
You want us to see 159?
My lord, yes, my lord, the order begins at 144. The analysis of the learned trial court is at 159.
Yes.
After considering all the arguments of all parties and police papers and looking at the facts on record, it is clear that the current applicant, Rita Ben, is the wife of the deceased. Accused Rajesh Bhai and Bharat Bhai are the deceased brother-in-law. According to the complaint, the deceased had a partnership with his brother-in-law, which led to disagreement over money, and the deceased left the partnership. After this, a dispute began between the deceased and accused, and also between husband and wife. Accused then filed a complaint under 498A against the deceased and current complainant, who is the deceased brother. Deceased brother has not been living with the party since, I'm sorry, my lord, I'm not reading. Deceased brothers has not been living with them for the past 28 years after his marriage, I'm instructed to say. After this, the deceased went to his brother and mother, told them that the accused were repeatedly harassing him, pressurizing him to leave the house he had got in the name of the accused Rita Ben, his wife, and threatening him. He also said that please allow me to argue. He also said that he was fed up with the harassment from the accused and wanted to commit suicide. On the day of the incident, the deceased sent an audio message in his society's WhatsApp group announcing that he was committing suicide due to harassment from the accused. Subsequently, when the deceased was admitted to the hospital, his statement to the police, dying declaration recorded by the executive magistrate, and the letter he wrote to his son and all other accused, the current defendant of the harassment. Affidavit from the investigating officer, not my statement, also stated that the deceased committed suicide due to harassment from the accused, that custodial interrogation of the accused is necessary, and that if they are released on bail, it will have a serious impact on society and public trust. Complainant submitted an affidavit stating that the deceased committed suicide due to harassment from the accused and requesting that he be not released on anticipatory bail. Considering all these circumstances as well as judgments, facts presented are not consistent with the facts of the current case as they do not help the accused. Thus, considering all the facts and circumstances, it appears that there is a prima facie case against the accused and the need for custodial interrogation is evident from the complaint. Therefore, it does not seem just to release the accused on anticipatory bail at this stage.
(306) is even if the person says I'm committing suicide because of this, it will not be enough by itself. I was just telling my brother there was another case where I think the wife told the husband, "Jaake mar," and he went and committed suicide. Even then he was acquitted. She was acquitted. Because just merely saying to "Jaake mar" doesn't mean that he has to follow what she said.
This is all a pressure tactic that was being employed on the.
The difficulty is the abetment of suicide standard is not subjective. It has to be objective. It can't be that a person says, I'm very sensitive. So if I even hear one word of criticism, I'm going to go commit suicide. Then any person saying that I'm committing suicide because of so-and-so, if we start convicting those people on that basis, then it becomes very difficult. You need to have an objective standard.
Right, Lord, unfortunately.
He died, no doubt. But he came to you also. In fact, this is at least a case where they did not ask him to commit suicide. He came and told you that he's going to commit suicide. What did you do about it? Did you send him for counseling? You also didn't do anything. That is their case, that you knew that he was going to commit suicide and you took no steps to stop him from.
Not me, meaning the brother, not
the family. Yes. He came and told the mother and the brother that I
went and lived
fed up with my wife and want to commit suicide. He tells you that I want to commit suicide. What did you do about it?
My lord, he started living with my lord, the mother and the brother.
Yeah, we'll grant protection for the time being. Let the reply come. We'll also want to see that dying declaration. Once the state comes, perhaps we'll be able to see it.
Very good.
Issue notice to the state of Gujarat returnable on 17th September. In the meanwhile, subject to is cooperating with the investigation in FIR investments of the petitioner shall not be arrested. He shall also abide by the stipulations.
Great.
May it please, minutes. A closely held company, intra-family dispute, my lords have felt that it will be settled by the mediation. In the meanwhile,
mediation is before whom?
Miller's,
J. Prabhakar in
one,
Sorry?
Mr. J. Prabhakar,
J. Prabha.
senior advocate in Hyderabad.
in Hyderabad.
But what are these prayers though? One prayer is to restrain the respondents from
Yes.
vitiating the atmosphere for
I'll
mediation.
provide the background.
No.
I'll provide.
What exactly are we supposed
See,
to
what
say?
happened?
How are they not to vitiate the atmosphere?
My last
The
game.
second one is even worse. Restrain the respondents from lying to the banks and financial institutions. How do we restrain them from lying?
Millers, with humility, let me submit, it needs to be what you call
What are these prayers, Mr.
It should be modulated, Millers.
Yeah, very-
May I submit one thing, Millers? The difficulty is this,
So,
Millers. We are more than
at the
willing to have.
mediation table,
Yes.
and you file these applications, obviously this
No,
mediation
Millers,
is headed
the
for-
problem is this, Millers. In the name of mediation, and we have all been waiting, they go about, complain to RBI, complain to Income Tax Department, complain to all bankers who have lent money. And have been choked completely, Millers. In that context, we wanted your lordship's
There's no
intervention.
point in
Now,
the entire exercise
Millers.
if these are the kind of applications you file. during
May I
the
pray for
mediation
one thing, Millers? May I pray for you? We have provided all proof with regard to what actions they have been taking when matter has been seized off by your
They
lordship.
can mediator and say that this is what is happening, please.
Kindly see, Millers, RBI has written to them that we can't interfere. Now, Millers, kindly, Millers, let the mediation go on. I'm not coming in the
mediation.
Millers,
Proceedings are in
no,
progress.
Millers.
We are not
May I seek
applying
one
to
thing,
entertain
Millers? Now the
this IA seeking
Millers, only one sentence, Millers, can I add?
comment. It is for the parties to work out their disputes, if possible, at the mediation table.
May I submit
And
one
not
thing, Millers?
seek intervention of the court during the said process.
May I submit one thing, Millers? Only with regard mediation. Mediation, Millers. No, I'm not on this point, Millers. When it comes to mediation, would my lords kindly appoint any retired
Why not? It's before the
judge of
mediator,
Islamic
why
Court
should
or the High Court?
Why
So
should
that
they interfere at this stage? How did this
No,
mediator
Millers.
come into the picture?
Millers,
Both of
so
you
far
agree.
nothing has moved. So far nothing has moved.
This court appointed. We are not going to the
No.
mediation center.
Millers, mediation center has allotted, Millers, not these your lordships.
Very well.
That's not
Whoever
correct.
it is.
Millers, at least may I pray, Millers?
Senior counsel of that court.
May I pray, Millers? I have no grievance. Only thing is, but could there be a time frame, Millers? It may drag on otherwise. Kindly say that, Millers, it could be 1 month or 8 weeks, whichever way your lordships feel.
Nothing. We are not going to fix
But
that.
otherwise, Millers, they will just have their sweet time. Meanwhile, I could not get loans, I could not run the factory.
Negotiate
I'm the majority shareholder.
We are not going to.
It's been stifling, Millers. Kindly indicate the time frame.
Sorry, Mr. Naidu. Are you dismissed?
So, great. Millers, may we be permitted to withdraw? Anyway, the practice, the prayer is neither here nor there. We'll just have
Having
it.
argued for some time, then senior counsel for the applicant seeks permission to withdraw the IA. Permission granted, the IA is according to this.
Millers, I still implore Millers some time.
After
frame.
dismissal.
The time frame, Millers, for the mediation, it has nothing to do with my application. So that things will move on, Millers. Great, deeply.
In terms of the last order, the amended memo of parties has been filed. The reply for respondent number 1 and 3 has also been filed a day before yesterday. It may not be on record.
I see, you filed a reply, right?
On behalf of R1 and R3, both are filed. And the last order had directed amended memo of parties to be filed. That has also been filed on the 19th of August.
It may not be on record,
Not filed.
it's filed is.
Current counsel for respondent number 1 states that the reply was filed on
26th of August.
26th
26th of August, 2020.
26th August. However, we do not find this thing on record. Do you need to file a rejoinder?
Yes, sir, in 2 weeks.
Current counsel.
R1 and R3 both are filed.
Appellant is permitted to file a rejoinder there.
2 weeks.
R1 and R3.
Yes.
Separate counter or?
Separate.
Replies have been filed by respondents 1 and 3. However, we do not find this same on record. Rejoinders that we can be filed by the next February. Based on so and so date, registry to verify and put up the replies by the separate. Date should be.
But sir, you need 2 weeks.
2 weeks you want?
Yes.
No, before the next.
17 September.
Yes.
21.
Short password maybe given. Senior counsel is.
You will have to organize CD player for us because I tried my best to find a CD player. Now, no laptop comes with a CD player. Earlier, laptops at least had that facility. But now, CD players are very, very difficult to come by. If you had given us a pen drive, at least we could have seen what was on that video. But you've given us a CD. I tried my best. None of my staff members also could find a CD player anywhere.
Sorry for that, sir.
If you could give us a
Right
pen
away,
drive,
right,
perhaps
yes.
we can
Right away.
we can see what is on that video.
Yes,
but the photographs that you filed do show that they are wielding guns.
Yes, my lord, no doubt.
And according to you, 5 victims were shot also.
Yes, my lord. Not a mention of that in the interview, lord.
We'll order notice, but in the meanwhile, give us a pen drive also.
I'll do that right away. Yes. I'm sorry for that.
Issue notice, returnable on 24th September. SATISH directed by all members, including Dusty. In the meanwhile, copy of the video filed by way of compact disc shall be furnished by way of a pen drive also.
Sir, can I hand it over to the court, sir?
You can file it in.
File it, my lord. Great.
That's one. Data. 22.
Yes, my lords, the matter stems from a matrimonial dispute. The complainant here is my mother-in-law, who has filed this FIR after 6 years.
Issue notice, returnable on.
Yes. My lords, for interim protection.
Returnable on 7th, 8th October. Meanwhile, the petitioner shall not be arrested in connection with so and so, subject to the condition that she cooperates with the investigation. 480.
Obliged.
23.
Yes, lords. The Tennessee FIR has been lodged after.
The High Court says that the trial is at a concluding stage.
Only 4 witnesses have been
Then
examined
on
out
what
of
basis
60.
did the state committee say that it's at a concluding stage?
No, Malad, that is not correct, Malad. Only 4 witnesses.
Maybe they will give up the other witnesses. Who said there are 11 witnesses?
16 witnesses.
16 witnesses. But look at para 7 of the order. The state law officer, as well as the learned counsel for the informant, have vehemently opposed the bill on the ground that 4 witnesses have been examined and the trial is at its conclusive end.
Malad, that is not correct, Malad. They have to come, Malad. Since that date, even the prosecution witness number 5 has not come, Malad. Malad, it is not correct. But Malad, may kindly see the evidence on record. I'll show it, Malad. Nothing is quoted, whatever is stated in the FIR, Malad. This is a totally false case, Malad. Grandparents, parents.
The victim has been examined.
Yes, she has been examined. Her father has been examined.
What does she say in her deposition?
Malad, she has agreed that she has not seen any audio or video. She has agreed that he never manipulated my her Aadhaar card. She's kindly see, I can read her statement, Malad.
Which page is it?
Malad,
Read it out, just tell us which page it is.
yes, Malad, PW2, Malad, is on page annexure P8. It starts from page 55. Malad, I just read few relevant papers. She kindly come to page 58, Malad. Malad, she says,
she does state that this rape did take place.
Yes.
no, Malad, she is saying, but this is not proved, Malad. You never went there. Malad,
Where is the question of proof?
no, Malad, this has not happened, Malad.
When the victim is saying that this happened,
Kindly see.
prima facie,
Malad, it is only 120 square yard house, Malad, with the 2 rooms on the ground floor, 2 on the upper floor. Malad, grandparents.
parents are downstairs.
Malad, parents, not only parents, Malad, grandparents, 3 paternal aunts, 3 paternal uncles, and everybody has been implicated in this POXO case, Malad. May kindly see, Malad, that this and all others have been granted bail, Malad. Malad, may kindly see what she says, Malad. She says, I went on my own.
Accused are there altogether? 11.
Malad,
11.
11 grandparents, Malad, a 70-year-old grandparent.
They are on bail, no?
They're all granted anticipatory bail.
This is the man who was raped her.
Malad, he is not raped her, Malad.
This is what the girl says before the court.
Malad, kindly see no audio video has.
This is what the girl has said in a statement before the.
Where is the person?
During COVID period, Malad, at night she said.
Once the victim says that you.
So no rape took place during COVID.
Kindly see, Malad, is it?
What is this?
See,
What kind of statement is this?
Malad, COVID period, Malad, at 9 o'clock, Malad, in the month of February,
She has named you, she has stated everything about you.
No, Malad,
It
but.
is not as if during COVID period, nobody was coming out of the house.
No, Malad, then Malad, she could have entered, then she went, Malad, she.
At this stage,
Medical.
we find no good ground.
People.
Sorry, we are not necessarily.
Malad, kindly
do
see
not
that the trial.
Any good ground.
That has been done by the High
To
Court.
interfere with the.
Last paragraph.
So as the High Court records that the trial is at the stage of conclusion. The special petition is accordingly dismissed.
For seeking anticipatory bail, it's a false case.
Details of that complainant.
Furnish the detail of complaint.
The complainant who's given that affidavit.
It's there, his affidavit is there, the details are there.
Details are also there.
Yes, but
Plead him as a risk.
just a second.
You'll have to give the details otherwise.
Page 17.
But the address is.
Well, this village,
The FIR, his address is furnished.
well, this says.
I already read the affidavit. We need his address. Where do you get the address of the complainant?
Well, some better address if it is there. Well, the village name, post office name, in villages it is like this only.
Name. So and so. We'll find the address also.
Yes.
Is implicated so number as respondent number 2.
Yes, sir.
Issue notice to the respondents returnable on 7/8 October. Inspection and service of benefits are almost including vesting. Well, in the meantime, the petitioner should not be arrested. He
Yes.
is mentioned with the file number so and so. Subject to his cooperative with the
I'm so grateful.
investigation.
I'm so grateful.
25.
Can I indicate what?
Same condition you comply with in the state of Jharkhand.
I have filed that additional documents is not on record. Would the lordship?
Grading scale ISO certification.
No,
How can you have an objection to
Not that, not that, not
That has
that.
been opened now, but 3 parties have filed notice.
Not that, this is not my objection. Can I indicate what is happening? Lordships will see the nature of supplies. Please have page 130 of the paper.
130.
Yes. What has to be supplied to a centrally sponsored scheme? Just have a look at what has to be supplied and what 130. Because 30,000 such kits of bat, ball, watches, batons, tops. This is the supply which has to be done to 30,000 schools all over Chhattisgarh. Large number of items all over the schools in India have to be supplied by various vendors. What Chhattisgarh says is, you must have supplied to the state of Chhattisgarh in the past.
All those have been changed.
No, Milos, that has not been changed, Milos.
The High Court.
No, Milos, it has not been changed. No, not at all. Let my learned friend says that.
Why didn't you argue it?
Because we argued it. The High Court says we won't interfere with the tender conditions. Because Lordship may take it from me. This
There is a specific paragraph.
No,
in the order
Milos, that has not been changed. That's the.
which records that both the learned council agreed that this is the.
No, Milos, that's not. That's why. Just have a look, Milos. Where Lordship are reading which page, Milos? The Chhattisgarh part remains. I am disqualified today.
Out of 4, 3.
Just 1 second, sir. Don't do this, please.
Some paragraph where.
Which says, Milos, please have page number 13, para 11.
Page number 13.
Para 11.
4 conditions. It is.
Pursuant to which 3 of the impugned have been amended. The challenge arise which forms subject matter of these 2 writ petitions. Which is this?
This is not disputed by the learned council.
So which is this? This is part of state of Chhattisgarh. That 2 words. That is the 4th condition is page 119. Bidding condition, Milos.
No, the 4 conditions are extracted at page 7.
Yes, my lords.
The fourth condition is all that survives is what is noted.
Yes, my lords.
Fourth condition is with regard to
My lords,
ISO,
I think-
NCD-SCO.
My lords, that but apparently the High Court has put it that the fourth, but there are totally in fourth, it may not be chronologically the fourth. If the state says out people who have supplied to other states are welcome, I have no difficulty, my lords. The difficulty today is 3 people have been supplying to the state of Chhattisgarh for years.
No, but can you see paragraph 18?
I know, my lords. Para 18.
Because para 18.
Yes, my lords. That's why we have filed additional documents last night. It has not come on record because yesterday was a holiday.
Please read para 18.
Yes, I can show Gujarat, which is on record. It says that similar states have other conditions. Lordships, this is exactly what your lordships are referring to.
Yeah.
Please see the state of Gujarat at page 63.
No, what about Jharkhand, Delhi?
That we have also filed, which have copies.
You obtained a contract in the state of Jharkhand.
Jharkhand. So I am from Ghaziabad. I would not be able to get a contract in Jharkhand, my
No,
lord.
this is, the respondents have demonstrated that such conditions are not unique to this state.
Because that is,
And the petitioner himself has successfully participated and obtained contracts.
Can I therefore say, because without taking the lord, it's not weighing scale, my lords. It's not weighing scale. Yes, my lords. Yes, my lords.
Bidders must have supplied at least 6 crores to the state government.
Yeah, of Chhattisgarh. Yes, my lords. Not to other states.
This is what they insist.
No, this paragraph says that similar conditions supplied.
Take
This
it.
is in reference to that.
Yes.
This is in reference to this.
It doesn't
Yes.
say so.
But it has to be because if you get it in Jharkhand and this is supplied to Jharkhand.
Yes, you have supplied to Jharkhand
I have supplied to Jharkhand
Earlier.
Yes.
earlier.
Or large number of states.
Please, one by
Yes,
one.
my lords. Yes.
And in Jharkhand, also there was a condition that in case you have supplied earlier to Jharkhand, you
Yes. Milos, can I place it on record? It was yesterday was a holiday, so we couldn't come on record. So I don't want to take your lordship's
So
time.
Jharkhand didn't have a similar condition.
No, and Gujarat we have placed on record. Lordships will mention Gujarat here also. Lordship sees Gujarat is also written here.
No, but why are you limiting it only to local people?
Because Chhattisgarh has a unique situation. We have Naxal infested areas. The projects, these supplies have to be taken to in 60 days. In all of
But
these.
why
five-
only
five-
local people?
Because not local people.
Not
You
local.
are saying that unless you have supplied to state government.
No, Milos, that's absolutely incorrect. Milos.
Chhattisgarh.
No, Milos.
That is one of your conditions.
Milos, the condition is that they must have had past experience, not local people at all. I'm so
Where,
sorry.
where is the amendment
Milos,
of this
these-
condition?
No, Milos, it's quoted in the impugn order itself, Milos.
Milos, what my learned
Please see, I'm
wants
so
to say.
sorry, Milos. Allow me to clarify. Please don't do this. Milos, my
He
point.
said that to you,
Well-
that you say it to him.
and you rightly said so.
It's welcome to say.
Milos, the condition is not that you must be registered in Chhattisgarh, you must be Chhattisgarh company. No, not at all, Milos.
This condition at
There was
page
previously a.
page 6.
Condition is that in case you have supplied goods earlier to Chhattisgarh, then only
Yes.
you can.
What- then you're in-
I've got on Milos. Only when you have experience with Chhattisgarh, you may be
Why?
CNR. No difficulty on that. Because Chhattisgarh has scheduled areas, Milos, where tribals are there, Milos. Then they have Naxal infested areas.
How is that relevant?
That is relevant, Milos, because.
These are sporting missions that need to be.
Yes,
supplied
absolutely,
to-
Milos. It is not easy to deliver those in those areas, Milos. They are dense jungles. We need to show some past experience of dealing with those areas. There are animosities, there are attacks, there are law and order issues, Milos. My reply is not on record. Please allow me to show, Milos. All of this was there before the High Court, Milos. And they run it in Jharkhand, it fell from my lords, absolutely right. When this condition is favorable to them, they win in Jharkhand. And now, my lord, they are the ones turning around and saying they don't even apply for tender. Now today the tender is open, my lord, 3 companies have won it already.
Those same
The-
companies
the
which are
both the
continuing
tender
for
and-
years, Milos.
That's not the ground, Milos. Where is the
No,
ground? Where is the-
I've raised that ground. It's all oligarchy. It's all oligopoly, Milos.
At least that much discussion has to be there to the state, Milos.
Of these conditions,
Man.
which is what is referred to in that.
Yes.
Page 13.
Yes.
19.
Yes.
Not 19.
It's page 191 is the amendment.
Where is it?
191. This clause is not amended.
But why did your counterpart agree that?
Because that's what happened. No, Milos, that what happened. Fourth condition, what High Court intended to say was this state of Chhattisgarh supply.
No, that is not how it is.
Milos, that
it extracts.
I know that,
number 4,
yes.
And then says,
but
and you agreed to it that only condition number 4.
My learned colleague appeared through VC. Here, the matter came up on first day. There is no reply even called for by the state. From the state, sorry, Lordships are reading something. Can I?
191.
191. So Lordships will see this Chhattisgarh part is not amended. Lordships will see that technical qualification of a bidder is he should have supplied to Chhattisgarh in the previous 3 years is not been amended. Weighing scale was amended, that CDSOC was removed. So weighing scale part below is a different issue. Today it may not arise or arise, that I'll address your lordship later, but the main grievance is about that outside state people are not allowed, or people who have not supplied to Chhattisgarh can't apply.
I'm sorry to intervene, Milos. That's not correct, Milos. I'm just saying past experience. They may be from Kerala, they may be from Karnataka. If they have past experience of dealing with that topography,
they will never have this past experience.
yes, they have, Milos.
No. If you're not permitting them to enter the state of Chhattisgarh with a condition like this, they will never have this past experience.
They came up with this condition only recently.
So there's a cartel of 3-4 people from the state of Chhattisgarh.
Correct.
They have the past experience and they'll continue to have that experience.
That's not been argued. That's not the case. But
what you are arguing?
It's not even there.
This is what you are.
That's the first time they're putting this.
We are asking you how the way you have fashioned it. There is no possibility of any outsider coming in because you've already got this condition. There's no question of getting their past experience.
No, that may not be correct. My humble submission.
Why did you come up with this condition only recently?
No, what's happening?
From when have you had this condition?
Instructions. I'm not aware of.
The concept of 1,000 crores, you are doing all this.
No, it's 15 crores. But it's for bad and all.
60 crores.
50 crores.
Notice. File your reply.
50 crores, roughly 50 crores. Sorry.
Yes. At this stage, perhaps no interim order.
No interim order.
But we will at least test their bona fides and see to it that they don't do this.
Milos, can I do one thing? Milos, can I do one thing? Lordships may interfere or not interfere is totally your lordships. I can give my tender, let the financial bids come, then your lordships will see that you opened it. The financial because it was not open.
That chapter is over.
This is kind of a from the state.
You have not even submitted a bid, is it?
Because it didn't take it. Because the I was not from
this stage. Where is the question of allowing you to submit a bid after the opening of the financial?
No, financial, let's make a statement that financial bid is open.
I'm instructed to state.
Let the management make a statement.
So we'll direct status quo.
Status
It has not been
Yes,
opened,
Milos.
I'm so
grateful. Very well. Status quo may be preferred.
Should notice returnable now. 24th September. Meanwhile, status for obtaining a sample shall be meeting as this affects the point.
My learned friend takes for both state and the Samagra Shiksha.
I'm only instructed to appear for the PSU, not for the state.
The Samagra Shiksha.
Trips notice. We have got respondent waves for the service.
Just to avoid
be affected upon these.
But just to avoid confusion, I am limiting my that to as Chhattisgarh. Lordship may next time again it shouldn't appear. That's why I am limiting my submission that people who have participated in the state of Chhattisgarh earlier tenders are allowed. That's all. That may be a confusion. My learned friend appeared through VC, so maybe he couldn't understand what is happening at the point. That's what he told me yesterday. Grateful to you.
Well, it's untainted teachers teaching presently in West Bengal.
Yes.
Item 26, my lord. Two issues on this, my lord. Which your lordships heard in the morning as well. We have explicitly said there is no sifting mechanism. They are allowing.
We will verify.
Yes.
At this point, stalling the process doesn't.
No, we're not asking for stalling. We're taking
so
the
we
exam.
will verify once the exam gets over.
Yes.
If you're able to show us that even a single tainted candidate has even been allowed to appear, whether they're selected or not is a different issue. If you have the list of details of who appear,
published the list, my lords.
No, that list is one thing.
Yes.
The people who appear, all that you will produce before us.
Yes.
We will
Because
take the
maybe
CBI in case you tamper with the tainted candidates list also, not to be trusted. So perhaps we'll have to bring in the CBI so they share with us directly the list of tainted candidates.
Candidate list has been published.
They're not.
That
published.
is, only
Even in the other matter, that was the same.
That kind. We have given the, after your lordships, when your lordships have passed the order, that they will continue up to 31st December. In every places, we have sent the names of only the untainted teachers.
Then they should file with your melons.
No, but
untainted teachers have.
High Court judgment required you to put it in the public domain. The
That is
list of
regarding
tainted candidates. We have not interfered with that direction. So that direction still stands.
Yes, yes.
Have you put the list of tainted candidates in the public domain?
Yes, Milord.
Have you? Or have you not?
Even in an affidavit.
Yes or no?
Yes, yes.
No,
yes.
No, my lords.
Yes.
No.
Even in an affidavit.
Where have you put it? Website of? Website, newspaper, how did you put it in the public domain?
I have been told that 952 persons' names have not been published.
Why have
that
you
is
not
untainted.
published?
Untainted.
No, tainted.
Tainted names have not been published.
Why?
That names have not been published.
Why are you keeping them secret?
But sir, with due respect to you, what kind of advocacy is this? I mean, your first sentence is something and then second sentence is something. Earlier you were telling us that yes, list has been published, it is on the website. Now, just after a few seconds, you say no.
I'm sorry.
But just by saying sorry, I mean, this is what I'm seeing all this in Supreme Court only. I mean, we trust you for this.
But untainted teachers, we have sent the names to
We are again and again telling you that we are not talking about the untainted teachers. We are talking about the tainted selected candidates whose names were directed to be put in the public domain.
We will publish the names within 7 days.
And this we will record. Learn it. You are appearing for the?
I am appearing for the SSC, School Service
Commission. Senior Standing Council appearing for the West Bengal Senior
School Service Commission. Central School Service Commission.
Secondary School. What is it?
Central School Service
Central School Service Commission states on instructions that the list of tainted candidates who were selected and whose selection has been set aside by the High Court and confirmed by this court would be placed in the public domain.
In the website, in our website.
That is on the website of the commission within 7 days. We take this statement on record, issue notice, reply, issue notice, return.
But only one thing I have to say here. In this case, all the petitioners have made their applications.
Well, let them
and they have got their admit cards.
Let them appear.
7th of September and the 14th.
Let them appear. List on 8th October. Reply, counter affidavit if any. Don't say if any. Counter affidavit shall be filed by the contesting respondent within 2 weeks, 3 weeks. Joined thereto if any may be filed within 2 weeks thereafter.
No other order.
So we also have an
No order in the line of
this.
previous filing.
Very well. We will also record that you are saying that they've already submitted.
Yes, yes.
You need an order otherwise? Do you need an order?
No, we have.
Learned Senior Counsel appearing for the commission further states that all the petitioners have already submitted their applications and that they would be permitted to appear in the examination scheduled to be held on 7th September 2025 without insisting upon their meeting the enhanced eligibility criteria as per the rules framed in the year 2025.
But 7th September and 14th September. 9, 10, 7, 11, 12, 14.
Sorry?
9, 10, that's 7th September. 11, 12.
11th, 12th is 14th September.
7th and 14th.
Melons, we also have an application for deletion of some pro forma respondents from the High Court, Melons. That may be allowed, Melons.
Which one is that?
This is 207659. I am 207659 of 2020. This is the very.
Yes. Yes. Amended memo of parties should be filed by the.
Yes. And my lords, if they don't publish the list in a week, why don't we come back to you, my lords? Yes, your lordships are monitoring. I'm so grateful.
I'm accepting notice on behalf.
Mr. So-and-so, then Councillor, give your name, please.
And I'll also accept it for the commission because our caveats were not filed. They come
Very
to
But this, whatever I have said, as a 7th, within 7 days. As a council, I am saying it should be published. That's the reason I am saying.
On instructions, we have noted this. Vivedi told you that you would be doing it.
But we have not published the.
Do it within 7 days.
Yes, sir. That is it. That is it.
Grateful.
27.
Confuse your lordships.
Bank is caught in this crossfire. No, the problem.
It's an order of the High Court. Where is
No, I know.
you're being caught?
No,
What is your local?
Trial court. The trial court, what I.
High Court now directs you to release the amount to him.
Well,
This is a High Court order. It has to be blamed. It is a High Court.
2 minutes. The
And
bank.
these are not even Parvinder Kaur's fixed deposits. These are his own fixed deposits.
That
You
is not.
committed the conversion already.
No, that was because we were not aware.
Committed to the conversion.
The file.
So these
What should
two fixed deposits stand in his name.
2 minutes. 2 minutes. Just 2. There's a consumer complaint against me. There's a criminal case I believe has been filed against me. The bank is getting involved.
Therefore, you are withholding his amount.
No, I'm not withdrawing. In case, initially the
Then
plea was
before all
released.
this happened,
The
you could have
trial-
filed an interpleader suit.
No, that's what the application.
Why did you do it before all this?
Application at page 79 is almost in the nature of interpreter when the trial court would say that give 20% now, the rest will be kept to the credit of the account.
Now the High Court says give the whole thing to him.
And there's a contempt now against me, my lord. It's today at 12 o'clock. I've been told to appear.
What's your locus?
No, the only thing the High Court could have been careful saying 45
If the High Court has directed you.
Yes.
Where is the question